Vijay sir, shall we start?
Yes, good to go.
Yeah. So good afternoon, everyone. I, Harshit Agarwal, representing Amity Innovation Incubator, welcome you all for today's session on process of patent filing in 60 minutes. Before starting today's session, I want to shed some light on Amity Innovation Incubator. We have started our operations way back in 2007 at our headquarters in Noida, with physical presence across 7 states, 17 virtual locations in India, and 7 locations abroad. We have assisted more than 500 ventures and have invested in 55 startups through Amity Capital Ventures, which is our investment vehicle. We are supported by DST, Atal Innovation Mission Niti Aayog, MSME, and Mighty Startup Hub. For more details on incubation and funding support, you can reach out to us on info@aii.amity.edu. Now, coming back on today's session, we have Ms. Latika Khanduja, founder director of IP Loya. She is having more than 10 years of experience in IP field. She supports startup and SMEs in their IP strategy, protecting innovation and providing support during IP litigation. She'll be sharing her experience about patent process in India and abroad as well, which we generally call PCT. So thank you so much, ma'am, for giving us your time. And over to you now. Please.
Thank you, Harshit, for giving me this opportunity. And I welcome all of you to today's webinar. And so let's begin with the webinar. So today, just a second. So today we'll discuss about a few points that you are already aware of. So for example, why we need to register a patent, what is the process of obtaining a patent, and after that, we'll move on to the main agenda point, that is the process of filing a patent in India. Not only India, I mean, let's say if Indian resident wants to file a patent in US or any other countries, then what is the process of doing that, and what are the different routes for filing a patent in different countries. So today we'll discuss these things. So let's begin with the first part. So that is, why do we need to register a patent? Okay, so probably you are already aware of these things, but I would like to again highlight few points on this part. So first of all, patents are basically used to stop anyone from copying your idea. Of course, that's your idea, and you do not want anyone else to copy it without taking your permission or giving royalty to you, right? Another reason for filing a patent is it acts as a source of revenue. So you might have heard of this person, that's Dr. Michael Doyle. So that person was a inventor or researcher like you and me in University of California. Okay, and he invented a web browser that supports plugin medias, right? And he invented this in 1990s, and he was intelligent enough to file a patent. And you know what happened in this case? He found that Microsoft, one of the biggest companies in the world, is using his patent protected technology. That's why he reached out to Microsoft for licensing, but Microsoft denied, and that's why he reached out to US court, and in return he was awarded damages of $521 million. That's the power of patents. I mean, you can think of this much revenue can be actually earned from protecting your idea. You might not actually get or generate this revenue by simply working on it without actually filing a patent. So another reason for filing a patent is it actually helps in gaining marketing edge and credibility. So actually you must have seen in case of various FMCG products that if you look at the product, they have actually mentioned patent number, or they actually use a tag patent pending. Why they do so? They actually do it in order to gain marketing edge over their competitors, to show that okay, my product is something which is new and I've got a patent on this, and that's why the quality uh, is better as compared to other products, right? Another reason for filing a patent is that it actually increases valuation of your company. So I was in discussion with various startups, and you know um, and they actually go for filing a patent because they want to increase valuation of the company, maybe by 2 times, 3 times, or 10 times. That depends upon lots of factors, right? So, because whenever you reach out to any investor, they want to know, first of all, that whether this idea is protected or not, because they also want to invest in an idea which is actually protected, so that nobody can enter their domain easily, right? So these are some of the advantages for filing a patent, and there are lots and lots of other advantages as well. But I would like to discuss only the obtaining a patent. So you might be aware of all these things, but I'll just quickly reiterate so that we are on the same page and nothing is missed. So the first step, which is optional but it is highly recommended, that we conduct a patentability search, okay, in order to confirm whether your idea is new or not. Okay, because this is very important, because if, let's say, your idea is not new and it is already published or patented by someone else, then there is no point in moving ahead and filing a patent, because it will actually use your money, I mean waste your money, and lots of efforts will go into this, and then there is no need for doing that. Okay, and this search is not only conducted in India but worldwide, because let's say if this idea is already patented or published by someone else in, let's say, US, then also we will not be able to get a patent in India. So this is very important step. So another step is drafting and filing a patent application in the patent office. So in this particular case, there are two types of applications that you can go for. So the first is, so one is the provisional patent application, another is non-provisional patent application. So we recommend that you go for provisional only and only when your invention is evolving. You are not sure that that, I mean, you got the basic idea, but your invention is still evolving. You still need some time to complete it. But in order to get a protection from day one, until you actually finalize your patent details, you can go for the provisional patent application. You can get the benefit of priority date, and then within 12 months you can file a regular patent application. But if you do not file a regular patent application within 12 months, the provisional application will be abandoned. Okay, and let's say if your idea is already completed, okay, and it is completely ready, then we recommend to go for non-provisional application directly. Okay, so once the patent application is drafted, we have to file the application in patent office. So as you might be aware that patents are territorial, that's why we have to file patent office in different countries respectively. So for example, let's say if you want to file a if you want to get the protection in India, you have to file patent application in India. Let's say if you want to take the protection in US as well, then you have to file patent application in US as well. Okay, there is nothing called a global patent. It's not like you file a patent application in India and you can enforce it in all the countries. Okay, you have to go in those countries individually. Okay, so moving on to the next step, that's publication. So once a patent application is filed, then it will be published after 18 months. So only the non-provisional application would be published. So this 18 months starts from the filing of the non-provisional patent application. But if you want to expedite this process, you can actually raise a request for early publication, and you can expedite this process. Okay. So once it is published, it will enter the queue for examination. So that's actually step 4. So in this particular case, the examiner would look at your patent application and see whether all the patentability criteria are met or not. Okay. So in this particular case, he will check whether your uh, invention is new or not, whether it is obvious or not, whether it is clear or not, and so on and so forth. So by this word obvious, I mean, I'm feature, and from another application, you're taking out another feature and you're simply aggregating these two. So that is, I mean, you won't get a grant on this part because the examiner would say that that's quite obvious. I mean, these two features were already existing in the past, and you have simply aggregated it. Okay. So once we receive any kind of examination report from the patent office, then we need to reply, we need to address each and every objection or rejection. And in most of the cases, it will come. I mean, do not panic on that part, because in general it will come. So once we have replied, and once, let's say, all the issues are addressed, then your patent application will be granted. But let's say the examiner is not convinced that your idea is actually unique, then he can also refuse the patent application as well. So that was the overall process for obtaining a patent. So let's just quickly look at the timelines for getting it. So let's say if you start with the provisional application, which is completely optional. I mean, you do not have to start with this, but let's say if your idea is still evolving, you can begin with the provisional application. And within 12 months of time period, you have to file a non-provisional patent application. If you do not do that, then your provisional application will be abandoned and you will lose out the priority date. Okay. So once the non-provisional application is filed, then from there, within 18 months, after 18 months, your patent application will be published. Okay. But if you want, you can expedite this process by raising a specific request. And once it is published, as I've mentioned, that it will be in the examination phase. And once everything is issued, then resolved, then your patent will be granted. Once it is granted, it will be valid for 20 years from the date of filing. After this, you won't be able to renew it, and you cannot do anything about it. It will be simply come in the public domain and anyone can use it. Okay. And during this period, I mean, until the patent is alive, you have to pay a maintenance fees, okay, which is very nominal. But in order to maintain the patent, you have to pay the maintenance fees. For example, website maintenance fee you pay, right? Similarly, you have to pay maintenance fees for patents as well. Okay. So let's move on to the main agenda point. That's process of filing a patent in India. Okay. So let's begin with that. So first of all, where you can file your patent application. Okay. So in India, there are 4 patent offices which are located in Delhi, Kolkata, Mumbai, and Chennai. Okay. And in order to file a patent application, appropriate office is selected. So there are certain criteria which has to be followed in order to file file a patent in specific office. Okay, there's some issue with this. Okay. So slides are visible. Please let me know if there is any issue. So in this particular case, there are specific criteria to select a patent office where you can file a patent application. So that depends mainly upon your location or your company's location. Okay. So basically the applicant location is used. Okay. Let's say there are multiple applicants. So the first applicant location, or the company's location, will be considered in order to select a particular office. Okay. And let's say if a person who is not Indian resident, he wants to file a patent in India, then in that case, location of the area of service of patent agent is considered. Okay. So I'll give you sort of the appropriate offices for just different jurisdiction. So for example, you can see that for state of Maharashtra, the appropriate office is Mumbai. So let's say if a person who has company is located in Goa, then in that case Mumbai would be the appropriate office. So we have to file the patent application in Mumbai. Okay. And let's say if in this particular case, the Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, these jurisdiction will be considered under Chennai. And Haryana, Himachal Pradesh, Punjab, Rajasthan, etc. would be considered under New Delhi. And rest of India would be under Kolkata. So we cannot simply select that, okay, let me file in New Delhi. That's not possible. So actually, that is selected based on the details of the applicant. And let's say if the applicant is not a resident of India, then patent agent details would be considered. Okay, I hope you got idea of this. So let's move on. So what are the documents required for protecting your idea? Okay, so there are, when we have to file a patent application, there are various forms and various details are required in those forms in order to file a patent application. So the primary thing, I mean, your invention. Okay, so your invention should be all the details. So for example, the specification, all the drawings, the claims of the patent application abstract, everything would be submitted using form number 2. Okay, and other details are also required. So for example, applicant details, inventor details, nationality or country of residence, address of applicant, phone number, contact details, email ID, and so on and so forth of applicant and inventor details are required. Some declarations, to declare that these are the inventors, and that we are the true and first inventors, and so on and so forth are also we have to provide. And also in order to make sure that the exam in order to actually request, we can also have to request for examination that, okay, we have submitted the patent application, now I request the controller or the examiner to examine the patent application. For that, we have to raise a specific request. Similarly, let's say if you want to expedite any process, so let's say you want to expedite the publication, early publication, or you want to file for the expedited examination, so separate requests for all these things would be um, we have to submit. And there are various forms. So each and every form have different utility. So for example, form number 18 is for a request for examination, form number 9 is for request for early publication, and so on and so forth. So we have to use these forms in order to file the patent, the specific requests. Okay, so let's see all these forms one by one in detail. Okay, so form number 1, I have this is the snapshot of the form number 1. So in this case, various details we have to provide. So for example, we have to provide applicant details. So as you can see that, this is the applicant name, nationality, country of residence, area, address of applicant, and similarly, inventor details are also required. And we have to submit that, okay, what type of application it is it a PCT application or the ordinary application, what type of application it is. Okay, also we have to provide details like the category of the applicant, whether the applicant is a natural person or individual, or whether the applicant is a startup, or whether the applicant is a university. So what kind of applicant it is. Okay, we have to provide all these details because the fee would be calculated based on that. Okay, other information that we have to provide in this form 1 is information of corresponding prior patent application corresponding to this patent application. Okay, so details about those. We have to also provide some sort of declaration. So for example, I'm the true and first inventor, and I'm the assignee, and something like that. So we have to provide all these declaration that there is no lawful ground of objection, and so on. So in addition to this, we have to provide other information as well. So for example, number of pages of your claims, specification, drawings, everything, and how much fees are you depositing, what means are you using to deposit the fees, and we also have to execute it. So your signature would be required in order to complete this. We have to file it. Okay. So let's move on to the next form. That's form number 2. So basically, form number 2 is used for for um, for submitting the provisional or the complete specification. So in this particular case, as you can see that, first of all, you have to mention that what type of specification it is, whether it is a provisional or it is complete specification. We also have to mention the title of the invention. We have to mention the details of the applicant and preamble to the description. And it is very important that we select preamble according to the type of specification. So for example, if you are submitting provisional one, then this particular, as you can see the left side, so there is a specific preamble to the provisional application, and for filing the complete specification, there is a specific preamble that we have to shortlist. Okay. And after that, the description, the detailed part of your invention and the claims abstract, everything you have to submit. And this particular thing, this form 2, they have to follow some sort of guidelines. So for example, there's a specific margin that we have to follow. So for example, top it should be 4 centimeter, left should be 4 centimeter, and something like that, right? And there is a specific font size, beyond which, I mean, you cannot go, you cannot go less than 1.5 or something. And sorry, 12. And the line spacing is also defined, and you have to uh, make sure that, so since this form contains the all the pages, all the drawings and everything, so you have to see the total number of pages in this form. So if it is exceeding 30 pages, because this form will contain each and everything, the abstract, drawings, claims, description, everything. So if it is exceeding 30 page numbers, then you have to pay different you have to pay amount for each additional page. So we'll talk about in detail later on. But all the pages would be considered in order to determine the total cost for filing a patent. Okay, so moving on to the next form, that's form number 3. So form number 3 is basically, a statement or undertaking, and under section 8. So in this particular case, basically you are uh, giving undertaking that you will be providing information about corresponding applications that you will be filing outside India, or you have filed outside India. So you have to periodically inform the controller about each and your status of the corresponding patent application that you have either filed outside India or you're planning to file outside India. Okay. Similarly, there are various forms. So, for example, so these are the snapshots of two different forms. So, the form 5 is basically to declare the inventorship, and the right side is basically form 18, which is used for requesting for examination. Okay, so in this we have to provide all the details. So, for example, um, name of the applicant, and and inventors if required, and so on and so forth, and of course signatures should be required. So these are some of the forms that I would like to share, because these are generally used forms. So in addition to these, you can also uh, look at form number 9, which is used for expediting, or for requesting for early publication. And there is a separate form. So let's say if you are a startup, okay, and if you want to avail uh, the benefits of startup, because the cost is different for different entities. So if you want to make sure that you want to have file the patent application at low cost, and you can use it, you can actually file a certificate. If you have DIPP certificate, then you can file as a proof that you are a startup. Okay, and for that you have to file a form number 28 as well, in order to show that okay, you are a startup, so you should get a benefit of the filing fees according to that. Okay, so similarly, case to case basis, there are different forms and everything. So let's say if you are hiring uh, if you are hiring a patent agent for doing this, so patent agent would require would have to submit form number 26. So that's basically a power of authority. So that means you are giving authority to the patent agent to file patent application on your behalf. So this is so moving on. So let's understand. Sorry. So this is snapshot of the just a second. Yeah, snapshot of the fees. So in this particular case, as you can see that there are different fees if you are going for physical filing or you are going for e-filing. Okay, first of all. Secondly, there are different fees for a natural person or startup. Okay, and there is a separate form for others. So for example, universities or big corporates, there is a separate column, right? So in this particular case, let's say for filing a patent application, let's say you want to file a non-provisional patent application and you are a startup. Okay, then in that case, you the filing fees that you have to provide is 1600 rupees. Okay, but in order to prove that you are a startup, you have to file a DIE certificate. You have to submit that as a proof along with form number 28. Okay, let's say if you do not want to file under your company name, then you can file it under your name only. In that case also the fees would remain same. That's 1600 rupees. Okay, so in this particular case, let's say your form number 2 that I've explained, that we have to count the number of pages. Okay, so let's say if that is exceeding 30, then there would be separate cost for each and every page. Okay, so as you can see, this is the amount. And in India, so there are basically 10 claims are allowed under this 1600 rupees. But let's say if you want to file additional claims, you can do that, but you have to pay additional fee for each and every claim. Okay, so beyond 10 you have to pay separate fees for every claim. So this is how you can see this fees in schedule 1. In if you just simply go to Indian Patent Office, you can see all these details. So for example, in this case, in order to submit the form 2, you do not have to pay any fees. It will be counted under 1600 only. And there are specific different fees for different things. So let's say if you want to expedite the publication part, so let's say you want to raise request for early publication, and if you're a startup, then the cost would be 2500 rupees in order to do that. Okay, and let's say if you want to expedite the examination and you're a startup, then the cost would be 8000 rupees. Okay, and let's say if you want to go with the normal examination phase, then the cost would be 4000 rupees. Okay, so this is how we have to see different costs. So you have to decide that based on these fees whether you want to expedite any of the process or not. And this, I mean, when you just scroll down, you can also see the maintenance fees as well. So for each and every year you can see how much you have to pay in order to keep the patent alive. Okay, so these are different you can actually go and have a look at it. So let's have a look at the actual website where we have to file a patent application. So I've just shown you a snapshot here. So in this particular case, you can actually if you can see my mouse, you can simply go to this new application part, and you can click on this, and after that you have to enter all the details. You have to upload all the forms and you have to enter as well. So uh, in this particular case, you have to see, okay, whether you want to you have to enter applicant details, inventor details, and each and everything you have to enter. And in this you can also see the schedules, and you can see the history that you have submitted, and the payment and the submission part, pending CBR. So each and everything you can see, and you can also select from different forms from here. So whatever is the requirement, you can actually do it from here. Okay. So let's move on and understand. Let's say if so, that was all about filing a filing process in India. However, let's say if you are Indian resident and if you want to file a patent application in different countries, okay, then what are the means for doing that? Okay, so let's understand this. So let's say if you are Indian resident and if you want to file a patent application in India as well as in US, okay, then what are the options you have? Okay, so the first option is that file a patent application in India. Okay, and that's this option is the easiest one. So file a patent application in India, wait for 6 weeks. Okay, after completion of 6 weeks, you can file a patent application in another country. Okay, that's the easiest option that you can select. However, if you believe that okay, I do not want to file patent application in India and you directly want to file a patent application in Europe, then what, or US, then what you have to do? Okay, so in this particular case you have to seek for a no, so in this particular case you have to share the details of your invention with the controller, and you have to ask permission whether this whether I can file it in US or not. And after raising the request, the controller will look at the request and see whether your invention is falling under a specific category where you are not allowed to file patent application. So for example, if that is concerning the national security or something like that, controller will refuse this application and he will not give you license to file a patent application outside India. Okay, but in most of the cases, if it is not hampering any national security, then you can get this license. Okay, so once you have received this license, you can file it in US or any other country where you want to go. Okay, but directly you cannot, if you are an Indian resident, you cannot directly file a patent application in US or Europe or any other country. You have to follow some protocols. Okay, and so basically in order to define a Indian resident, so these are some of the uh, things that we have to consider. So let's say when a person would be considered as is that he's a Indian resident. So in this case we have to see the number of years that he has spent in India during specific time, and there are other criteria as well. So based on that these protocols have to be followed. Okay, so let's understand, the different routes. So let's say if you want to file a patent application in different countries and multiple countries, then what are the different routes that you have to follow in order to file it? So broadly, you have two options. So the first one is Paris Convention route. So in this, I mean, this is the simplest one. So basically, in this particular case, what you have to do, file a patent application in one country. So let's say in your case, it would be India. Okay. Use the priority date of the patent application. Okay. And then file a patent application of the same invention, of course, in other country within 12 months. Okay. So that means, let's say, if you want to file a patent application in India, US, and Japan. Okay. So in this particular case, just file a patent application in India, use the priority of this one, and file a patent application in US as well as Japan within 12 months from the priority date. Okay. So that's option number one. The other option is, let's say if you want to file a patent application in multiple countries, and also if you want to if you want some more time to decide okay where you want to actually enter in different countries, then another route is the PCT route, that's Patent Corporation Treaty. So in this particular case, how it works is that file a patent application in one country. Okay, use this priority and file a PCT application within 12 months of the priority. Okay, and once this PCT application is filed, then you have to enter different countries individually within 30 or 31 months from the date of priority. Okay, so let's understand this PCT in detail. So, this is the timeline that you can refer. So, in this particular case, let's say you file a provisional patent application in India. Okay, and that's the priority date in India. Okay, so in this particular case, you have to file a PCT application within 12 months. Okay, once the PCT application is filed, then it will enter the international phase. Okay, so in this case, there would be specific search authorities that we have to select while filing a PCT application, and that search authority will conduct a search, patentability search, in order to check whether your idea is unique or not, and they will generate international source report and written opinion. Okay, that this is what they believe, and so this international source report is basically a source report which is generated or prepared by international search authority that you will select while filing the PCT application. So once that part is done, of course, you can use this kind of source report to understand where all you want to file a patent application. So you can understand, okay, this patent application seems very strong, then I should, enter more countries or less countries. So that's completely up to you. So you can understand it by, simply looking at the search report. So once it is done, you have to enter national phase. So that means you have to enter different countries separately within 30 or 31 months from the date of priority. Okay, so in some countries it is 30 months, and for other countries it is 31 months. So for example, in India it is 31 months from the date of priority. So this is about the PCT part, and of course, this is this would actually give you time. So in this particular case, I'll give you example that, let's say, if you want to enter US, China, and Japan, then it is recommended that you can simply go for the uh, Paris Convention route. So in this particular case, you can file a patent application in India, and then within 12 months, you can file different countries. I mean, these three countries through Paris Convention route. But if you need some more time, then you can also, look for the PCT application route, and you can enter the national phase within 30 or 31 months of time. Okay, but this time period is very important, it's very critical. You cannot go beyond this. I mean, if you miss on this particular part, then you will lose out the priority date. Okay, so I hope this was clear, and now we can discuss how we can help you in getting a patent. So let's say, in first case, we can provide free ideation and innovation consultancy to you. So in this particular case, let's say if you're not sure that, okay, that you have this product, but you are not sure that, I mean, what particular case, you can come to us. I will, we'll conduct, or we will examine your product in detail and share the potential features that can be patent protected. Because I understand that, you might not be able to extract that, okay, this particular part is important and this should be patented. So, there are various few things as well. So for example, I'll give you very small example. You might have heard of, Amazon's one click patent. Okay, so what was that? It was nothing but, that patent was about, instead of adding to the cart a particular product, you can simply click on the buy now button, and you can simply place the order by clicking on one product, one button. So that was, I mean, you can think of that, it's a very small thing, but they have actually filed a patent on this, and that was actually a revolutionary one. I mean, a lot of companies went to Amazon to get a license on this particular thing because that's quite user friendly, right? So that's why, you have to think in this particular fashion, okay, that, of course, the idea that you believe is unique should be protected, but overall also we have to see what all can be patented. So after this, after extracting the potential features, we will of course get in touch with you, and based on your approval, we can conduct a patentability search to confirm whether this idea is actually unique or not. And as I've mentioned that this step is very important, because if this particular part, I mean, if your idea is not really unique, then probably you do not want to proceed with this because it will save your time, effort, and everything, right? And this is also help in improvising or fine tuning the patent application as well. So this is highly recommended that you go for the patentability search to see where your idea is standing in the market. Okay. After this, and this conduct is conducted worldwide and not just India. So let's say if somebody in US has already published this idea, then you cannot get a patent in India. Okay. After this, we can help you in drafting the patent application. So let's say if you want to begin with the provisional one, we can start with the provisional one. And let's say if you want to begin with the non-provisional, then we can draft the non-provisional patent application. So that's completely based on your preference, and based on the thing that where your I mean, if your idea is actually um, completed or not, or it is still under completion phase. Okay. So after this, we'll help you in filing the patent application at patent office. So in this case, let's say if you want to get the protection in India, we will file the patent application in India. And if you want to get the protection in US as well, we will file the patent application in US as well. Okay. Because as I've mentioned, patents are territorial and there is nothing called a global patent. It's not possible that, if you file patent application in India, you will get grant. I mean, you can enforce in different countries. So that's not possible. Okay. So once that part is done, so we once the filing is done, we can also support you in the patent examination process. Okay. So in this part, whenever the examiner would generate some sort of examination report, we will help you in addressing all these things. We will also help you in attending all the hearings. I mean, you don't have to go there. You don't have to go for a hearing. We will take care of all these things, and we'll make sure that you get a grant on the patent application. We can, of course, try our best to do that. So once the patent application is granted, then of course you can commercialize the product or commercialize your patent application. So the commercialization actually happens in different phases. So for example, you can actually license your patent application. You can also uh, sell your patent, not the application, because now it's granted. And of course, as you can understand, the commercialization will be um based on the granted patent, of course, because the scope is defined at the time of grant, and it is not on the pending application or on the provisional patent application. Okay. So we can also support you in some phases in the patent commercialization as well. So in this particular case, I'll give you a 2-3 minutes background about the commercialization. So in this case, let's say we can help you in supporting whether your idea is actually used by someone else or not. So we can actually find infringement that this product is actually using your product. Okay. And also there is a separate type of licensing as well. So in other is the technology licensing. In this particular case, we have to find companies, or who needs your invention. I mean, they have not really infringed as of now, but they want to use they might need your invention. So we have to identify those companies who would be benefited after using your patent application. So these are the some of the ways through which you can license your patent application patent. And of course, you can of course sell the patent whenever, if somebody is willing to give that. So that was all, and I would like to thank you everyone for attending today's webinar. And you can follow my firm IP Lawyer on LinkedIn in order to know more about patents, and how you can go about it, because I usually post weekly posts on LinkedIn. In You can also visit my website at www.iplawyer.com. You can contact me directly at latika.khanduja@iplawyer.com, or at info@iplawyer.com. And feel free to directly call me at 9811 in order to understand more about it. Thank you very much. Over to you, Harshit.
Thank you so much for this knowledgeable session, ma'am. We have a few questions, ma'am.
Sure.
So one is, ma'am, if I use Form 9 for the early publication, how much time it will take for grant?
So for early publication, you are actually filing for early publication, not the grant. So in this particular case, the patent application would be published. So in general, it will be published after 18 months, but now it will be published up before 6 months. You can say. So there is no set timelines, but you can say that before 6 months. So sometimes it takes only 1 week as well. And if you want, you can also expedite the patent application examination phase as well, in order to. Hello. Hello.
Yes, ma'am. I think Harshit.
Yes, ma'am.
Yeah, sorry. So I was saying that you can also expedite the examination phase as well, in order to get early grant on it.
So, ma'am, one more question. Can Indian consultants file a PCT application?
Yes, we can do that.
Okay.
So in form number 1, as I've mentioned, that if let's say you have to mention which type of application it is, whether it is ordinary application or it is PCT application, you can file it.
Okay. How can we get patent for research topics?
So it's basically, there are different I mean, if your idea is actually new and it is not obvious, then you can file a patent application for the same. However, there are few categories that are not patentable in India. So for example, method for doing agriculture, or let's say if there is
Hello.
Hello, can you hear me, Harshit?
Yes, ma'am. You're audible. You're audible.
Okay. So let's say if you have discovered any living or non-living thing, or you have discovered any scientific principle, so there are a few categories which are not patentable. But otherwise, if let's say your idea is unique and it is not obvious, then of course you can get a patent on it.
Ma'am, we have a next question. It says, do we file patents individually or with help of patent agent?
Yeah. So you can file the patent application by your own. Nobody is stopping you. However, you might have technical expertise, because of course, you have spent a lot of time in developing your technology. However, you might not be having, legal expertise. So because this is very important, because patents are basically, you can consider this as, patents are basically used for creating a boundary around your invention. And if that boundary or the scope is narrow, then the commercial value would be less, of course, right? But if let's say you take professional help, they will make sure that they will use their legal expertise and make sure that the scope or the boundary of your invention is broader, so that you have a commercial value of your patent application. So it is highly recommended that you take professional help from patent agents or attorneys in that. but nobody is stopping you to do that by yourself.
Ma'am, we have a next question from Mishti Goyal. She's asking, can we get patent for digital projects?
So I am not sure what's that.
Ma'am, I'll just unmute Mishti. So
Sure.
I think she would be in a better position to, actually clarify what exactly her concern here is.
Sure.
Mishti, please ask your question.
So if your question is around, filing a patent on the software part, then of course, you can get a grant on that. So, okay, was it on design part? Okay, so yes, I mean for design, there is a separate category that's considered under design registration. You can protect your design through design registration.
Ma'am, we have our next question. As you mentioned that if a US patent exists of a similar nature without a further PCT application by the inventor, and this allows us to file the patent in India. So similarly, if we file a new patent in India without filing a PCT, would it stop others in US, UK to get similar patent there?
Yes, I mean, let's say in US also, if somebody wants to file a patent application, then a search would be conducted by the examiner whether this art is already there anywhere else also. So let's say if any art is already published in India, then in that case, US person would not be able to get a patent on that because it was already being published in the world before he actually filed a patent.
Ma'am, we have Prashant, one of our startups incubated in Gurgaon. So he
Mhm.
would like to ask this question on call.
Okay.
Hello. We are a pre-doc and we have filed two patents. One is a provisional and one is a complete patent. And what I wanted to ask was that, I saw a lot of patents of, in software-based patents mainly, and that for one particular problem, there are multiple patents filed in different kind of ways. So what I wanted to know is like how how protectable are patents in India, especially software patents, where where using a different method, we have filed another patent, a new company comes in, files a new different kind of methodology, and files another patent. So are they protectable, or what's the scenario?
So yes, I mean the very important part is that the how part is very important. So for example, you might be using Amazon. Okay, so in that you have seen a recommendation engine, that recommends similar products to a user. Okay, so in this particular case, Amazon might be using a specific algorithm which may include anything. So for example, number of clicks by a user on a particular product in a specific timeline, based on his location, his age, or anything like that, right? So let's say he has filed a patent on these parameters. Let's say if another company, Flipkart, comes and he also is recommending similar products to a user. However, the parameters they are using, or the scores they are using, or the way that Flipkart is recommending is different from Amazon. Okay, so in this particular case, he can actually Flipkart can actually file a patent because the process that he is using, it is new and it is not being patented or published by Amazon. So the how part is very important, that how recommendation engine of Amazon is working, how recommendation engine of Flipkart is working, and like that. So the process has to be new. So in this case, the Flipkart, if he's having a new process which is not used by anyone else, then he can file a patent. I hope I have answered your query.
Yes, ma'am.
Thank you.
So I think that, Harsha, do we have any further questions?
Thank you so much. No, So thank you so much, ma'am, for this knowledgeable session. I hope and I believe now our startup got a fair idea like how to file a patent in India and abroad as well. So with your permission, can I like I can circulate your contact details in our startup group, so that if they have any query regarding patents or trademark, they can directly connect you.
Definitely, sir. I'll be
Okay,
happy
okay,
to
ma'am.
address those queries.
Sure, ma'am. Sure. So I'll share your email and your contact number with our startups, so that in case of any query, they can directly connect.
Definitely, sir. I'll be
Thank you.
happy to address those queries. Thank you.
Okay. Thank you so much, ma'am. Thank you so much.
Thank
Thank you,
you so
ma'am.
much, everyone, for joining today's session. Hope you find it useful.
Yes, ma'am. Okay.
Thank you, ma'am. Thank you for your time.
Bye-bye.